In the legal system of each state, cases involving will disputes, elder financial abuse, and breach of fiduciary duty are initially argued in probate and chancery court. These are their stories.
Hello, I'm David Russell, editor of wealthandhonor.com, and welcome to Wealth and Honor, the Case Files, where we undertake a non-legal analysis of actual court cases involving will disputes, elder financial abuse, and estate litigation. Now, before we get started, let me remind the viewers that I am not a lawyer. My commentary should not be taken as legal advice or expert legal opinion. If you find yourself in circumstances such as what we're about to review, you should hire a lawyer licensed in your state to advise you. No, the reason for examining these cases is to learn from the mistakes of others and hopefully keep ourselves, our clients, or our loved ones out of the courtroom. Most advisors will tell you that the courtroom should be the arbiter of last resort. But we do have these public records, these stories to learn from. And so my intent is not to air another family's dirty laundry or to gloat in their misfortune, but to look for the warning signs that our own families might have in common with these. We'll look at the parties involved, the context of their lives, and the decisions that were made that may have led to conflict and litigation. Perhaps their experiences will spare your family from avoidable conflict later on. Before you watch this episode, if you've not viewed the presentation on frequently used terms in the case files, I recommend you watch it first to familiarize yourself with many of the terms used throughout the case files. As with each episode, characters identified in the court transcripts are portrayed as characters in popular TV sitcoms or dramas. I think this gives the characters depth and often adds a touch of humor to an otherwise serious legal matter. For now, I hope you enjoy this episode of Wealth and Honor, the Case Files. Well, for those of you who appreciate the sitcom Arrested Development, I hope you enjoyed this presentation of the facts. But let's dig deeper now into this case to find out where this family tripped. Now, the first warning sign is Robert's multiple marriages. We know that Robert had been married 3 times, not counting his twice marriage to Lois. And multiple marriages are almost always a warning sign for potential conflict. We've all heard the tabloid stories of former spouses of celebrities or famous individuals who suddenly reappear after that individual dies, claiming they are owed something from the deceased estate. Well, that's because even when divorce has been legally settled, an ex-spouse may still have valid claims against a deceased estate, and multiple ex-spouses only increase this potential for conflict. Now, this potential for conflict only magnifies when there are children from these multiple marriages. We know that Robert had 3 children from 2 prior marriages, none of whom were the biological child of Lois. Lois also had 2 children from her prior marriage, neither of whom were the biological child of Robert. Whether valid or not, heirs may prosecute a claim against a deceased parent's estate, and minor children are normally given preference by the courts over their adult half-siblings. This presence of multiple heirs is a certain warning sign for potential conflict. Now, we also know from the court transcripts that Robert was a wealthy individual, reported to have been worth millions of dollars upon his death. Now, while conflict can and certainly does happen, even when there isn't great wealth, the more wealth that is at stake, the greater the likelihood for conflict. A disgruntled heir is less likely to incur the cost necessary to prosecute a claim against an estate where there is little to gain, but the prospect of significant gain may encourage an heir who feels left out of their fair share to seek compensation in the courts. Now, the court transcript describes Robert's estate plan as a complicated plan. Now, this is likely due to the fact that his estate was comprised of various commercial real estate projects in Northern and Southern California, projects that were likely owned by various business entities or had other complex tax and ownership issues. So it's reasonable that his estate plan would have been complicated. Now, we don't know this for certain, but in my opinion, this complication was also likely due to complex tax planning that would have been necessary to reduce the federal estate tax that could have claimed up to 55% of Robert's estate when he died in 2009. Often such complicated tax planning overlooks other issues, such as incapacity planning or inheritance planning, or the entire plan has so many moving parts that heirs become confused, and this confusion can lead to conflict. An heir looking for problems may conclude that the complexity is there only to hide something that just isn't right. Finally, we know that Robert executed many changes to his estate plan over the years. In fact, the court resolved to enforce the terms of the 10th Amendment, voiding several amendments that were executed afterwards. Now, estate plans will change. I encourage people to plan for a 10-year window of time depending on their age, because changes will likely occur in their personal life as well as in the laws that will necessitate a change. But changes that occur at the whim of the person creating the plan can leave behind a paper trail that can bring into question just what the person really intended and whether they were influenced by outside forces every time they changed their mind. It can plant enough doubt in the minds of others intent on proving that the plan enforced at death was not really the plan intended by the deceased, as evidenced by earlier plans that may have had different outcomes. So to recap, there were at least 5 warning signs that Robert's family and advisors should have been aware of and could have been addressed proactively to have avoided the results that occurred. Multiple marriages, children from multiple marriages, significant wealth, millions of dollars according to the court transcripts, a complicated estate plan, and several amendments made over the years. So with the advantage of hindsight, what are some things that could have been done? Now, even hindsight is not 20/20. Human behavior is not so predictable that we can look at this case and come up with a neat list of things that would have changed the results for this family, or our own for that matter. Hindsight can only offer suggestions. The first thing that could have been done is for there to have been better communication among the family. This is a classic, easier said than done observation, of course, but it does indicate the value of clear, intentional communication. It may not have had to involve all the members. Getting step-siblings and ex-spouses in one room to have a kumbaya is not what I'm inferring here. But some kind of communication apart from the sterile legal documents could have communicated Robert's intent. Some people write what are known as ethical wills, or leave video messages behind to state their wishes for their families and the values they hope to leave behind. In my practice, I recommend to each of my clients over the age of 70 that we conduct a family retreat where questions about who does what when can be fully addressed and questions can be asked in a safe and moderated environment. Second, I also think Robert could have had better representation by his legal team. Now, I'm being a little unfair here because it's possible that they tried to make Robert aware of the issues he was creating with the frequent changes in his plan, along with the complexity that his plan had. Perhaps his team could have placed as much emphasis on incapacity and inheritance issues as they did with tax planning. We really don't know. What is more certain is that Lois's attorney acted unethically at best when he agreed to prepare a plan for Robert at Lois's direction without ascertaining Robert's understanding of the plan and apparently even meeting with him. Lastly, the healthcare industry needs to be more proactive with aging clients and their families. Patient privacy aside, the healthcare team needs to be more proactive with assessing a patient's ability to make complex decisions, manage finances, and alerting an authorized person about cognitive decline. Cognitive impairment, not just Alzheimer's disease, will affect most older individuals at some point prior to their death, and the healthcare team should be a part of the overall team that serves the aging client. Lintz versus Lintz has several lessons that any family can learn from. Unfortunately for the Lintz family, it involved an expensive legal resolution and worse, a division of family relationships. Until next time, I'm David Russell, and thank you for watching this episode of Wealth and Honor, The Case Files.